on behalf of the defendant is Mr. Jim Archibald and John Malick. Welcome. The purpose of today's hearing, Mr. Best, is called an arraignment, and it is to introduce you into district court and to ensure that you have been provided a copy of the charging document, which in this case was the indictment, and to inform you of the potential charges and the potential punishment, and to take your plea. Mr. Best, have you been provided a copy of the indictment?
I have.
And I intend on providing you with a summary of the charges and potential punishment. If you prefer, however, I will formally read you the indictment language. Is the summary sufficient, or would you prefer that I read you the formal reading?
The summary is sufficient.
All right, then let's turn, and if it's in front of you, then that's terrific, but I'm pleased to hear that you've received it. I'm looking at the indictment at this time, and I will call your attention to 3 counts of murder in the first degree, and would share with you that the potential punishment for each of these 3 counts include punishment of up to life in prison or death, a minimum sentence of 10 years without the possibility of parole, a $50,000 fine, and a civil penalty consistent with 195307 of a $5,000 compensatory fine. Also, looking at the indictment, there are part 2s to each of these 3 counts. And the allegation is that in the commission of the counts of murder, there was the use of a firearm or some other deadly weapon during that commission. The punishment for this weapon enhancement is up to an additional 15 years of incarceration. Each of these counts and the respective enhancements may run concurrently or consecutively. Mr. Best, did you review or view the video, the rights video, prior to today's hearing?
I did.
Thank you. Understanding, counsel and Mr. Best, the potential punishment that is associated with this case, in a moment I'll ask you to consider how you would like to proceed. But before that, I will ask you, Mr. Best, with the aid of your counsel, what your intentions are today with regards to your plea. Is it to enter a plea of guilty, not guilty, or to stand silent, wherein the court would enter the not guilty plea on your behalf? Mr. Archibald, have you had that conversation with your client?
Yes, Your Honor. He's authorized me to enter a not guilty plea on his behalf.
Very well, then I will direct Madam Clerk to enter the not guilty plea. And in response to that, and in consideration of the potential punishment, the court invites the parties to consider 2 potential ways to proceed. The first is, we could set our next matter for a status conference some 60 days from now, allowing the discovery to continue to be provided and allow the state its 60 days as permitted by 18-4004A to contemplate its intent on pursuing certain available punishments. This approach would also allow a more thoughtful consideration after review of the discovery that's provided up to that stage of the proceedings to decide the kind of trial setting you would like, how far out and how many days for trial you might be suggesting. Alternatively, if counsel prefers, then we could certainly today set the matter for trial at this time, understanding that we may very well come back together again within that 60 days for other proceedings. Mr. Archibald, do you have a preference between those 2 approaches?
Your Honor, I'm okay either way, so long as a status conference is set within 60 days, or at the conclusion of the 60 days, rather, so the state can make a determination whether it intends to file the notice of death penalty. And if the death penalty notice is filed, then I would anticipate a trial setting over a year out. Typically, our mitigation and mental health experts want at least a year to prepare for a trial. If the death notice is not filed, then we can set the trial within 6 months from today.
Thank you. Ms. Smith, do you have a preference between those options?
Your Honor, I believe setting a status conference makes most sense at this juncture.
Okay, and frankly, counsel, that's my view as well. I think that allows, as I indicated, additional discovery to be provided and then allowing everyone the opportunity to fully consider how many days and maybe a more thoughtful setting for trial. And so, Madam Clerk, if you will look at the calendar and set a status conference at least 60 days from today. And to give you a little direction, I'm comfortable, as we did for this hearing, at 1 o'clock in one of the afternoons. If there's a preference, given the calendar settings in Teton County, I should be available really any day of the week for a 1 o'clock setting. I can make my adjustments.
Your Honor, from the state's perspective, the state has several trials calendared March 4th through 8th. Aside from that, though, the state can make most any afternoon work.
We do have March the 1st, which is a Friday.
Okay. Given the number of days in January and February, I think we need to go a little beyond March the 1st, I think. So what about the week of March 11th?
We go ahead and do the 14th or the 15th.
Okay, Council, do you have a preference between those 2 days?
Your Honor, and we also have the 19th and the 21st.
Okay. Council, without objection, I'm going to suggest March the 14th at 1 o'clock for our status conference. Okay.
That works for the state.
Very good. Getting indications from the defense as well. And as that approaches, perhaps we can have conversations as to whether that hearing, similarly to the way we've conducted today's hearing, should be over Zoom, or if it makes sense to gather in Teton County. So thank you for that setting. There are a couple of other issues that I would just bring for discussion. And that is, Mr. Best, as you shared with me that you viewed the rights video that was played for you, you understand that you are not entitled to bond at this time. Today, you are relying on the services of Mr. Archibald as a public defender. Is it your intention to continue this representation through the proceedings?
It is.
And as such, I would need to make a finding of indigency to ensure that you qualify. And so, Mr. Archibald, will you assist the defendant in completing an application?
Yes, Your Honor.
And I will watch for that submission and be able to make my findings associated with that event. And then lastly, and I've noted that Mr. Malik is here joining us, we understand that under Rule 44.3, I would share with you that the trial court administrator and I would be working together to identify co-counsel as a qualified second chair, should that become necessary. And so I just raised that issue to highlight the fact that that discussion will take place. Is there anything associated with that issue, Mr. Archibald, you would like to add?
Your Honor, I've reviewed with Mr. Malik the qualifications, the application that's necessary to be submitted to the Public Defense Commission. So I believe he's working on that paperwork. Whether that application is reviewed and approved prior to 60 days up, I don't know that. So we'll take that matter up as it comes up. Right now, I am fine with Mr. Malik proceeding if the court is. I know he's not today on the roster of qualified co-counsel, but in another case I handled, the Public Defense Commission allowed another attorney to work with me so long as his application was pending. So I don't know the court's take on that, and so I'll defer to the court.
Okay, thank you. I think I would ask of you to just keep the court informed, and in turn we will apprise the state. And I'm comfortable for purposes of today's proceeding, and then we will await to see if that authorization is approved. I won't make any comments about the involvement of Mr. Malik at that time. I'll leave to your discretion and your understanding of the rule and the ethics associated with his assistance of counsel. But until then, obviously, and through today's proceedings, it's the court's reliance upon you, Mr. Archibald, as first chair.
Very good. Thank you. Okay.
Counsel, those are the things that I wanted to accomplish today. Is there anything that each of you would want to visit about?
Typically we have a resource judge that's available for funding for defense expenses under the Idaho Capital Crimes Fund. I don't know if that determination has been made yet by the court.
Okay, thank you. I don't think that it has, but I will, again, on this issue, visit with the trial court administrator and seek that assignment.
Very, very good.
Anything from you, Ms. Smith?
No, Your Honor, not at this time.
Okay. Well, council, thank you all. And we will see you at our next